No, do you get tired of hearing your own biography read? Well, I don't mind. I think I'll get in trouble if I don't read it, so. Good morning, testing. Good morning, everyone. I think we're going to begin the next panel. Today's panel is titled General Law in Historical Perspective. And the moderator of this panel is Professor Ann Woolhandler. The description of this panel sort of builds on the previous discussion we just heard. The panel focuses on how courts have engaged with general law over time from the founding era to the present. For example, how did general law principles shape the original meaning of the Constitution? How did their decline alter a constitutional principle and interpretation? And can modern originalists reconstruct these principles despite gaps in the evidentiary record? Panelists will explore the general law's role in early constitutional adjudication, its displacement after Erie, and the implications of its decline for contemporary originalist theory. As I mentioned, Professor Woolhandler will be moderating the panel. Professor Woolhandler is the William Minor Lyle Professor of Law at the University of Virginia School of Law. She's an expert in the federal court system, civil procedure, and administrative law. Professor Woolhandler received her undergraduate degree from Yale before obtaining her JD from Harvard Law School. So please join me in welcoming Professor Ann Woolhandler.
I'm to introduce our distinguished panel. First, today will be Stephanie Barclay, who is a professor at the Georgetown Law School. She's a distinguished scholar, teacher, and advocate. Her work has focused on intersections of free speech and religious exercise. She earned her JD from the BYU Law School, and she is in the process of completing her DPhil at Oxford. She is clerk for Randy Smith on the Ninth Circuit and for Justice Gorsuch on the Supreme Court. Remotely appearing today will be Brad Clark, a professor at the GW Law School. He's a prolific scholar and has, inter alia, focused on the intersection of the law of nations with constitutional law. After graduating from Columbia Law School, he clerked for Judge Bork on the D.C. Circuit and for Justice Scalia on the Supreme Court. And of course, we have our own John Harrison, who is a professor of law, a distinguished professor of law, in fact. He has taught nearly every course on the curriculum, and we consider him expert on almost everything, including constitutional law and history, federal courts, remedies, and conflicts. He earned his JD from Yale and clerked for Judge Bork on the D.C. Circuit. He served at the DOJ in various capacities for a decade before he came here. His work at the DOJ included his service as Deputy Assistant Attorney General in the Office of Legal Counsel. I'll start with Professor Barclay, who will speak for 10 to 15 minutes, and then we'll open up some questions as to what she says for the time for 10 or 15 minutes as well.
Thank you. Thank you for that kind introduction. Thank you to the organizers of this terrific event for hosting me. And what a treat to be on such a distinguished panel. It's rare to be an expert in everything, but John Harrison is definitely that, and so it's a treat to be speaking with him. So for my remarks today, I want to start with one area that I think there ought to be, in my view, there is emphatic agreement and overlap between general law principles and originalism, public meaning originalism as I understand it. I want to then, my second point will be one area where I have a different read, or at least an area of potential disagreement, and then I'll end with a question, or an area where the relationship between general law and originalism at least gives me some pause. So first, I think Professor Campbell and Professor Sachs and Professor Bode have all done really important work helping draw attention to ways in which general law draws attention to the content of law that existed and is separate from the Constitution, but that might inform the Constitution. And I'm going to draw particularly on the excellent articles that Professor Campbell has written about First Amendment law, and including his article that just came out in the Harvard Law Review that I recommend to you called Determining Rights. So, but in that vein, I do want to flag that this conference has language in some of your pamphlets or the description about what do we do when the text runs out. But I think another way of potentially thinking about some of these issues are, what do we do when the text points us to the general law? Because that may be, in fact, what's going on with clauses of the Constitution like the First Amendment, where it says, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. Note the article, the. The idea that perhaps there is this existing understanding of what constitutes the right to free exercise of religion that is not created or brought into being by this text, but that text, almost as a placeholder, is referencing. It's like that thing we all understand and we know that with the content that exists, that's what we're referencing and protecting in the First Amendment. There's evidence that Professor Campbell points to about some of the pre-existing content of these understandings. Michael McConnell has written about this. I think other historical evidence about the idea that there's already a pre-existing understanding of free exercise of religion come from people like George Washington, who in his letter to the Quakers, before the First Amendment was even written, wrote that the liberty enjoyed by the people of these states of worshiping Almighty God agreeable to their consciences is not only among the choicest of their blessings, but also of their rights. And so he's calling this a right before it's the First Amendment, and even though some states haven't protected it yet in their state bills of rights. Religious exercise can be viewed as a number of different types of rights, but certainly a natural right, the type of right that was retained by the people, is inalienable, and in the compact, the social contract between government and people, is not the type of right that just governments would interfere with needlessly. That doesn't mean that it's an unlimited right. James Wilson wrote about how private and individual rights are subservient to the public good. And that's just one of many examples of quotes I could point you to, the idea that natural rights were viewed as having limitations internal to them that were related to the common good, which is, I think, relevant also for the text of the First Amendment, which doesn't reference limitations on free exercise. And so a lot of scholars have puzzled over that. Does that mean that the free exercise clause or the freedom of speech clause are protecting an unlimited right or a categorical right? I think that might be an example of us treating the text as though it is bringing this right into being, as opposed to looking at that text as pointing to pre-existing content. So that's just one example of ways in which the general law and original understanding of constitutional text aren't in tension with each other. Understanding the role that general law is playing when it comes to constitutional text can help inform and enrich our understanding of that text as an originalist. Okay, so one area where I want to talk about, where I read the evidence slightly differently than Professor Campbell, and some of this is based on my article that's forthcoming as a response in the Harvard Law Review called Constructing Constitutional Rights, is that Professor Campbell argues that enumerating constitutional rights in the Bill of Rights was neither a necessary nor a sufficient basis for judicial enforcement of those rights. And I think Professor Campbell's absolutely right that it wasn't a necessary condition to enforce those rights, because a lot of courts thought that they might have that authority just inherent in just limitations on government. But I think it was a sufficient basis for enforcement of those rights. So let me just walk through some of the evidence that I think is relevant to this idea that the fact that a right or a provision in the Constitution is declaratory doesn't mean that it is not also an alternative source of law. In other words, it can provide another source of law for enforcement of pre-existing content of law that is part of the general law. So one source which Professor Campbell himself has referenced is the federal farmer, who argued during the ratification debates that, quote, constitutional or fundamental rights could not, quote, be altered or abolished by the ordinary laws, end quote, included by rights that either, and here's the quote again, claim under solemn compacts of the people as constitution, or at least under laws so strengthened by long usage as not to be repealed by the ordinary legislature. That's a mouthful, but I think Federal Farmer is saying there are two ways in which you can ensure that ordinary laws aren't going to abolish rights, either through our constitutional documents, either by enumerating rights or by the custom and long usage that is going to make these rights, customary rights, deeply entrenched, sort of fundamental rights. As another example, during the first Congress's debate about the Eighth Amendment, Mr. Livermore is describing the relationship between declaratory rights and making new law. He says, quote, "We ought not to be restrained from making necessary law by any declaration of this kind." In other words, he's both saying that what they're doing is declaratory and saying we're making new law. New law in the sense of potentially a way of enforcing what is declaratory of existing general law. Madison, when he introduces the Bill of Rights, I think can also plausibly be interpreted this way. Professor Campbell has said that when Madison talks about independent tribunals of justice will consider themselves a peculiar manner the guardians of these rights, that Madison is just talking about judicial psychology. So a prediction of what courts will likely do, but not really a description of a new legal basis for courts to do that thing, for courts to be guardians of rights. And that's one potential way to read that language, but I think maybe a more straightforward way to read what Madison is talking about is that the Bill of Rights wasn't necessary for some of these rights to be safeguarded, but it provides another legal basis, sort of a belt and suspenders means, if you will. He talks about how, here's a quote, that although some disagree that the Bills of Rights are necessary, they do not argue that such a, quote, declaration of rights is ineffectual, which I think is another way of saying that we're not arguing that it's irrelevant. We're not arguing that it's doing nothing. He also spends some time in this speech talking about the need to proceed with caution with changes, lest the, quote, door be open for reconsideration of principles and the substance of the power that's being given, end quote. He also talks about how some bills of rights that exist in the states are defective because they're not protecting rights in the appropriate way, which suggests that it does matter who the enforcement is directed at and how some of these rights are written. And he spent some time talking about who he thinks that some of these bills of rights ought to be directed at as well. And some of what Madison's speech is doing is reiterating statements by the judiciary from Hamilton, who says in Federalist Number 78 that the interpretation of laws is going to be the peculiar province of the courts. A constitution is, in fact, and must be regarded as fundamental law. It therefore belongs to them to ascertain its meaning. Now, it might be the case that where some of the meaning is ambiguous or less determinate, that's going to provide less of a basis for courts to facially strike down statutes, because there's also a lot of evidence talking about ways in which the conflict between legislative work product and the constitutional principle has to be pretty clear, has to be a pretty clear violation. But Hamilton also talks about the importance of judges in mitigating the severity and confining the operation of such laws. They don't have a term at the time for as-applied constitutional remedies. I have written about and argued about how what courts are doing at this time when they have multiple potential interpretations of a statute, but when it butts up something that might be like a constitutional right, a press right, or a First Amendment right, they're more likely to interpret the statute in the way that does not cause that sort of a conflict. So it's like sometimes constitutional avoidance on steroids, which conceptually is quite similar to what courts do now when they say we're just not going to allow this particular interpretation or this application of the law when it results in this constitutional violation, even though the law is otherwise good law and will apply it in a whole lot of other contexts and stay on the books. Elsewhere, state founding-era courts explained that a legislative act that was repugnant to a Bill of Rights was ineffectual and inadmissible, and that the said action should be dismissed, which suggests, again, there's real legal effect coming from bills of rights. One federal court took it to be obvious that state legislatures could not annul declaratory rights that were natural and indeterminate, but that were enumerated in state constitutions. That court said, could the legislature have annulled these articles respecting religion and the rights of conscience? Surely not. So I think that one thing that I do agree with Professor Campbell about those, that the purpose of enumerating rights was not just for the judiciary. And I think sometimes we do have a tendency to fixate too much on the judicial role with respect to rights. So Professor Campbell has written about the educating function of rights. In one of his articles, he talked about how when we enumerated rights, this, quote, served in guiding political officials and shaping public opinion, goals that undergirded most calls for declaration of rights during the ensuing ratification controversy. This point is worth emphasizing. The leading reason for enumerating rights in the late 1780s was, he says, has nothing to do with courts. I would just amend this to say, in my view, was not just about courts and judges. And so we often, I think, downplay at one of the most important parts of rights, which is to tell political officials, this matters a lot, this principle, this value, and you should act to protect it. And in my forthcoming article, Constitutional Rights as Protected Reasons, coming out in the Chicago Law Review, that's one argument that I make there, is that yes, there's a role for judges, and I think one consistent with history, especially when it comes to policing certain justifications that government could not act on to interfere with rights, the types of justifications that would not have been consistent with advancing the common good at the founding. And judges have an important role in policing that and making sure there's really a conflict between the type of justification government articulates and the type of interest that the right is going to protect in a given context. But rights also create a strong, weighty reason for political officials to protect them, and I think that's worth emphasizing. The last question that I just have is about this idea that Bode and Sachs and Campbell write about when it comes to the general law and the 14th Amendment. They say that perhaps the first 8 amendments themselves referred to general law principles that were capable of developing over time through a course of long-standing legal practice. If so, the 14th Amendment could then refer to some of the same rights as those secured in the Bill of Rights, but without the Constitution freezing either sets of rights in legal amber. So I think this is a really interesting but potentially troubling way in which general law and originalism might interact, is that if this is the best understanding of what was going on with the 14th Amendment and the first 8 amendments, and those rights were just acting as placeholders for law that would continue to evolve, I think that does raise interesting questions about who gets to decide what are the new rights and how it's evolving. Is the judiciary really competent to do so? A lot of the normative justifications for originalism, I think, are certainly less applicable if that's how we understand the relationship between general law and original meaning. I say that even though, rights I care about a lot, like the Free Exercise Clause, I think would fare pretty well because Congress, under the Religious Freedom Restoration Act, nearly unanimously passed a statute giving robust protection to religious exercise. More than half of the states have as well. So if we had this sort of evolving notion of rights, then strong, strict scrutiny is the way to go for religious exercise, regardless of what you thought about at the founding. But I worry about how some of the other rights would fare, and I worry about the judicial competence to be able to decide just exactly how much involvement is enough. Maybe they should be out of the business altogether. The bottom line is I have a lot of questions, and I hope that some of the conversation we have today might flesh out. Is this the best way to understand the relationship between general law and originalism, or are other ways better? And if this is, how do we reconcile some of those tensions? I'll go ahead and stop there.
Thank you. Professor Barclay, do you have some questions or anyone before we proceed? Yes. I don't know if your speaker, if your microphone person will come.
Thanks so much for being here. My question is, if I were to find a place in the Constitution, or if I were to try to find a place in the Constitution that either sanctioned or pointed directly toward a body of unwritten law, I would think about the 9th and 10th Amendments, which are, if not completely irrelevant, like mostly irrelevant to modern constitutional jurisprudence. Do you think there's a greater role for them with this body of law, or do you think they've kind of been relegated to obsolescence, or maybe they don't have anything to say about the general law?
I do think that there's room for a greater role for both of those amendments, but I hesitate to say too much when our nation's leading expert on the Ninth Amendment, is in the room. So maybe you should ask Professor Barnett that question when he gets up. So yeah, I do think that there's more of a role for them, but I won't get into a ton, I think, what that should look like. Yeah, preview of coming attractions.
Do we have other questions? Yes.
Professor Barclay, I was very curious thinking about kind of the early evidence of how the free exercise clause was enforced by the state government. So I think you recently wrote an article where you were saying that some pretty kind of unseemly practices from present day point of view were being practiced that were repressing religious exercise. And we're thinking about like kind of the Rahimi debates and the liquidation debates about what kind of practices should be permissible today. You know, Professor Bode was just talking about how, well, maybe with respect to like burglars being executed, that might actually be permissible. And so when we're thinking about the free exercise clause, what level of generality really should we put the analysis at when we're figuring out how to apply that today?
Yeah, great question. So I think you might be referencing a blog post that I co-wrote with Professor Michael McConnell, Doug Laycock, and Mark Storsley. It's also, that post is citing to my forthcoming Harvard Law Review response. The concern that we have about if we Bruinized the free exercise clause, it's a word we made up, is the following. We all, on some level, think that founding era history is really important to understand the rights enumerated in the Bill of Rights. And Professor McConnell and Mark Storsley and I would all call ourselves originalists. Professor Laycock is a little bit more of a constitutional pluralist. I also think that historical analogs of practices that were going on around the founding period can be really relevant to understanding constitutional meaning. But they're evidence. They are not like equal to constitutional meaning. So let me give you an example of a historical analog that I think is helpful and that I would recommend that we analyze at a really low level of generality. And then I'll contrast that with the approach in Bruin and why I think it's problematic. So under the Establishment Clause, the same Congress that was debating and ratifying the language for the Establishment Clause, I think later the same week, put in place legislation to establish a chaplain for that Congress. So it's really close in time. It's the same actors. That is, I think, super strong evidence that whatever they thought the Establishment Clause meant, they did not think that having chaplains pray in Congress was a violation of that meaning. And I do think that what we are trying to get at when we're interpreting the Constitution is not just like high abstract purposes for the Constitution, unless we're in the construction zone, which is separate. But if we're trying to identify meaning, we're trying to figure out what was the law that they understood to be creating with the Constitution. Michael McConnell has written an article about some of the different hallmarks of what constituted an establishment. He has identified 6 of them. The Supreme Court, in their opinion in Kennedy, that let us know that Lemon had apparently been overruled long ago, and they were just announcing it. They reference those 6 hallmarks of what constituted an establishment in a footnote when they're flagging that coercion is not the only thing relevant for looking at what constituted a violation of the Establishment Clause. And those hallmarks are, again, at a pretty low level of generality. Note that the Establishment Clause, as we've interpreted it, provides categorical prohibitions on government. You cannot do this thing. And in that context, I think both judicial restraint and predictability go hand in hand when we interpret the Establishment Clause facts and those hallmarks at a low level of generality. It's clear what exactly the prohibited action was that government can't engage in, and that also creates a narrower sphere of things that will invalidate government action, which puts the judiciary on less of a collision course with democratic institutions. It's a problem with Lemon. Lemon had a really high level of abstraction, very fuzzy test that put judges on collision course with democratic actions all the time and gave us very little predictability about how it was going to go. So Bruin isn't identifying the historical analog of the thing that government cannot do. Bruin flips it because in the establishment context, the analog is the prohibition. In Bruin, the historical analog becomes the permission. So this is the only thing you can do, government, is you must point to a historical analog of this type of regulation if you would like your regulation now to be permissible. And it effectively creates a categorical right where I think it is more clearly understood as being a defeasible right, meaning that government should be able to override that constitutional right for some reasons and for justifications that are relevant to the common good, which if it means anything, the common good will change depending on the particular circumstances of what a society needs. So when you flip it so that the historical analog is not a prohibition, but it's a permission, there's going to be strong temptation for the judiciary to then raise the level of generality. Because if they keep it at a very low level of generality, we're basically handcuffing government from being able to do anything. We saw that in Rahimi. The level of generality starts to go up, right? But note that when you have switched it from a prohibition to a permission, now the level of generality, which is relevant to judicial restraint, and predictability are at odds with each other. They are not pointing in the same direction, they're in tension. Because as the level of generality goes down, and so we have more predictability, the interference with the democratic process goes up. We're going to strike down far more democratically enacted work product in that context. The other problem with Bruin, which we point to as relevant in the free exercise clause, another area where I think it's a right that's defeasible, not meant to be, generally speaking, categorical, is that Bruin has this unstated assumption that whatever the regulations were at the founding, A, were permissible, but B, were also the extent of what legislatures or political actors could constitutionally do. And that's just a big assumption to make without justification. I think unless we know that legislatures were saying, we can only go this far and no farther, we shouldn't assume it. But in the free exercise context, it's problematic because unlike the Establishment Clause context, where we have strong evidence that that historical analog was constitutional, there are a lot of examples of behaviors, including by state actors, that Madison pointed out. He said there's almost been no state Bill of Rights that hasn't been violated at one time or another. And I think some of the state blasphemy laws might be an example of government actors not living up to the ideals of free exercise. And so we shouldn't assume that historical regulations were the limit of government authority, but nor should we assume that they are necessarily examples of constitutional government authority. It's a question where we have to look at them carefully and say, was the evidence of this historical analog, based on the relevant actors, based on the relevant context, good evidence of the meaning of this constitutional right or not? Sorry, that was long answer.
Oh, thank you. I think we'll move on to Professor Clark, who joins us from GW.
Great, thank you. Can you hear me? Yes. All right. So I want to address this topic of general law, and thanks to the FedSoc for putting this on at UVA today. This is a great topic and very timely. When I'm speaking today, I'm going to be speaking about views that I've developed over time with my longtime co-author, A.J. Balia from Notre Dame Law School. And we've been writing about the law of nations and the Constitution for quite a while. We had a 2012 article in the University of Virginia Law Review, and we had a subsequent book, among other articles. We had a subsequent book, which I'll show you, The Law of Nations and the United States Constitution, in which we try to delve into some of these topics. And so I'm going to summarize some of that here today and then speak a little bit about Swift and Erie and where we are today. So I think we need to start with definition, right? What is general law, or what was general law at the time of the founding? And this can be a little bit amorphous, but generally speaking, it was a body of law that was voluntarily adopted and applied by multiple nations to facilitate their friendly relations and commerce across borders. So Blackstone said that general law in that sense was largely synonymous with the law of nations. And at the time of the founding, according to Blackstone, there were three main branches of the law of nations: the general commercial law, or the law merchant, the general maritime law, or the law maritime, and the general law of state-state relations. And that's the area that regulates how nations treat each other and their representatives. Now, also, choice of law was a general law topic, but it wasn't thought of as, it was more, that was a judicial doctrine. These other doctrines really regulated how people behaved and then would, provide rules of decision for adjudication of disputes. So notice that all three of these areas of general law dealt with interactions among nations or their citizens, and the goal was to establish uniform rules for the mutual benefit of everyone involved. And nations opted to follow general law rules not out of any obligation to a superior sovereign, but because such rules facilitated their relations and prosperity, right? So with this background in mind, we can distinguish general law from several other kinds of law recognized at the founding, such as local law, common law, and unwritten law. And local law was the opposite of general law. Whereas general law governed transactions among multiple sovereigns, local law governed intra-territorial matters within a single nation or state. As Justice Story explained it in Swift versus Tyson, local law governed, quote, rights and titles to things having a permanent locality, such as the rights and titles to real estate and other matters immovable and intra-territorial, unquote. And this will be relevant when we discuss Erie. Significantly, tort law was historically considered local law because the law of the place had the right to establish the applicable law that governed the wrong when it occurred. Now, the common law was not synonymous with general law because the common law of England, for example, incorporated both general and local law. So although sometimes we think of them as interchangeable, they're really not from a historical perspective. Same thing with unwritten law. General law was unwritten law, but not all unwritten law was general law. So in the United States, early American courts applied general law in the sense I've described it, the three branches, where it applied. A lot of times they applied it without explaining why they were applying it. Part of that is probably due to the fact that the common law adopted the general law in England, and the states adopted or received the common law after they achieved their independence. So state courts applied general law just as English courts had. And in particular, they applied general commercial law routinely. Now, Swift versus Tyson was a case involving a question of general commercial law. And of course, it was a federal diversity case in which a federal judge, the Supreme Court in this case, decided that the court disagreed with New York court's interpretation of general commercial law. And the Supreme Court said, we have the right to exercise independent judgment. We can decide what the content of general law is, just as the state courts could, right? And that's why state courts were not bound by the Supreme Court's decision in subsequent cases in state court. Now, our position is Swift was entirely defensible when it was decided, because as Story emphasized, New York courts did not purport to fix the content of general law, but rather to find that content. And federal courts have the same right as New York courts to find the content of general law and apply it in cases where they had jurisdiction. Now, and it was uncontroversial at the time. Swift was not controversial. It was mainly cited in the decades following for the substantive commercial law rule that it announced. And subsequent state courts didn't follow it in some cases. Now, what happened was, leading up to Erie, the Swift doctrine expanded over time, and it became problematic for two reasons. So first of all, states started localizing commercial law. both through judicial decisions and state statutes. And if you think about it for a minute, you've all studied the Uniform Commercial Code. Around the turn of the 19th century, around 1900, there became a movement for uniform state commercial laws to replace what was lost with the localization of general commercial law. And today, of course, UCC incorporates many of the principles that come directly from the traditional law merchant or general commercial law. But with this breakdown of general law, we know it was very difficult for federal courts to say, well, we're just doing what state courts do. We're applying general law if general law of commercial relations no longer existed. And secondly, and I think most importantly, federal courts over time, from the time Swift was decided in 1842 till Erie in 1938, they continually expanded the scope of so-called general law to include historically local matters such as torts and property law. And they were never governed by general law. So that brings us to Erie in 1938. And I'm going to disagree with Will's comments a little earlier about Erie's constitutional rationale. I think there's some overbroad language in the opinion, but we think the decision was constitutionally correct on the facts before the court, right? This was a diversity case involving tort law. What was the duty of care owed by a railroad to a pedestrian walking along the tracks or the right-of-way? And the railroad said Tompkins was a trespasser under Pennsylvania law, and therefore they had a very low duty. But the lower court of appeals agreed with Tompkins that general law applied and imposed a more onerous duty on the railroad. Supreme Court sided with the railroad and overruled the Swift Doctrine and said the Constitution requires federal courts sitting in diversity to apply state law rather than so-called general law. Now, there is a problem here with maybe throwing the baby out with the bathwater, which I'll come to in a minute. But on the facts of Erie with tort law, there was never a general law of torts in the sense I described earlier, right? A law that many sovereigns adhered to for their mutual benefit. There certainly was overlapping tort law, and much of American tort law stayed similar for a long time because all of the states initially received the common law of England and then gradually refined it over time to create differences. But tort law was always local law, not general law. So states had the right to control it. So in a case like Erie, we agree with the court that it was unconstitutional for federal courts in diversity to create their own general law of torts because under the Constitution, the only basis federal courts have for disregarding state law in areas over which states retain authority is the Supremacy Clause. And it only recognizes three sources of law as the supreme law of the land. This Constitution, the laws of the United States made in pursuance thereof, which I would interpret as statutes, and treaties. And in the absence of that, any of those sources of law, the Constitution allows states to govern as they see fit. And the Swift Doctrine was allowing federal courts to interfere with state governance of state matters in a local area. So, all right, well, but that doesn't mean that all general law is to be disregarded in federal court. And maybe the court wrote over broadly on that point. But I'll tell you, on the same day, and it's clear the court didn't mean to throw out all general law, because on the same day the court decided Erie, it decided a case involving water rights between states, and it applied general law. On the same day, Hinterleiter versus La Plata. And I won't go into that because that's more complicated, but let me move on to some general law areas that the court subsequently has continued to recognize and still applies today. So very quickly, historically, there was this law of prize, which I'm going to skip for now because I don't want to run out of time. But in the modern era, post-Erie, the Supreme Court has recognized what it calls the Act of State Doctrine. And that doctrine really has its roots in the general law of nations or the law of state-state relations. Under the law of nations, all sovereign states enjoyed territorial sovereignty within their borders. And other states were supposed to recognize that sovereignty. So that brings us to the Act of State doctrine. The way the Supreme Court formulated it in 1964 in its Sabatino decision, the court said the Act of State doctrine provides that neither federal nor state courts may, quote, examine the validity of a taking of property within its own territory by a foreign sovereign government, extant and recognized by this country at the time of suit, in the absence of a treaty or other ambiguous agreement regarding controlling legal principles. In other words, this idea, this general law idea of territorial sovereignty must be respected by federal and state courts. Erie notwithstanding, and they specifically say, we don't think Erie had the Act of State doctrine in mind. Now, they don't go into a lot of detail, but our theory is this is an area of general law that interacts with the Constitution and its allocation of powers to the political branches to conduct foreign relations. So we'll talk about that later. Now, one last example, which is still extant today, is head of state immunity. So at the founding, foreign sovereign immunity, diplomatic immunity, head of state immunity, they were all a matter of general law, and they were part of the law of state-state relations. So when nations would recognize each other, it would carry with it this basket of general law rights and obligations. Now, in the 20th century, Congress has codified foreign sovereign immunity and diplomatic immunity, but it's never codified head of state immunity. And in 2010, the Supreme Court decided that in a suit against the former Prime Minister of Somalia, the Foreign Sovereign Immunity Act did not provide immunity, but this individual may be entitled to immunity under the common law, according to the court, without specifying more what was the source of the common law. Well, we would say the best source is the continuing general law of head of state immunity and how it relates to the Constitution's allocation of powers. So Erie restricted general law, especially where the lower courts had expanded general law to local matters such as torts, but it really didn't throw out the entire baby as head of state immunity cases and Act of State cases show. So I'll leave it at that.
Okay, do we have questions from the audience, from Professor Clark? Or Professor Clark, I should say.
Hey, Brad. So I'm curious about the extent to which we disagree as a matter of labels and the extent to which we disagree as a matter of substance. So on the labels, I'm not really interested in fighting you. I do think there's an important distinction between the type of general law rule that is at issue in Swift versus Tyson and the type that I would say is at issue in intrastate cases, which is ordinary common law, quintessentially. And I'm happy to distinguish those and to say the distinction actually does matter for choice of law issues. I think that's what Story is getting at in Swift versus Tyson. But I'm curious about, so two things. One, can we at least agree on the substance? And then second, what is the common law if it's not local in character? And so on the first, are you open to the possibility that there is a body of trans-jurisdictional law that governs intrastate matters? So are you open to a pre-realist idea that there's a common body of law that can be revised by various states pursuant to local regulation, but that states are able to adopt, if they choose, to govern a variety of disputes that are going to come up in various states? So, for instance, are you open to the idea that there could be what we call general law, a trans-jurisdictional body of law that governs property matters or that governs tort matters? And if so, why not accept that as the understanding that people at the founding are embracing when they're asserting that they have rights as English, the rights of Englishmen, or that people in the antebellum period are asserting when they're asserting that they have rights, a common body of privileges and immunities as citizens of the United States. In other words, I'm happy to take your terminological distinctions on board, and they have some substantive weight to them, but what do you say about the existence of such a body? Do you deny that it either could or did exist? And then the sort of related question I have is, I'm a little confused what you think the common law is. So you say the common law is some combination of general law and local law, but for somebody like Blackstone, property is quintessentially common law, and he distinguishes property from local law, the law of a local manor or whatever within England. And if you look to various common law authorities, like let's say Cook on Littleton, it's a property treatise. Like the quintessential common law source at the time is a property treatise, and it's all about the common law, not local law. And so I'm just curious what to make of that.
Yeah, so let me start with the last question first. I think the common law was the law of England. It got exported to former colonies over time, but it was municipal law of England, right? It only applied in England. It didn't apply in France. So what was it? Well, it was a body of law that the judges applied in the common law courts, and it incorporated the general law sometimes. So you'll see there's famous opinions by common law judges saying we follow the general law of nations on certain questions. Why? Because it made sense to do so to further the purposes of general law, like general commercial law, maritime law, admiralty law, law of state-state relations. Prize law, I didn't get into, but prize law was and of course in England they had separate admiralty courts, and they adopted the law of nations as their law. But they're a local court, just as common law courts were, right? They're a municipal court in a sense. And so I guess I would just say the common law was allowed to incorporate the general law when it wanted to, just as states could adopt and change the common law as they saw fit. Now, on the first question, is there a transnational body of tort or property law? I mean, there's certainly similarities, but see, this fixation on the common law puzzles me, especially when we think about general law, because common law was an English concept, and there were many other nations who followed the law of nations and general commercial law or other branches of the general law, and they had nothing to do with common law. Now, they may have had some similar concepts of responsibility or wrongs to tort law, or they might have had similar concepts to property law. It doesn't make them general law in the sense that I understand it. General law, the goal of general law was to provide uniform rules for nations to get along peacefully, right? Use of the high seas, right? Neutral use of the high seas. We all have the right to use it. If you interfere with it, it might be just cause for war. We all would like to have more commerce and trade across borders, and to facilitate that, our merchants need to know what the rules are. But, and that would be helpful, right? If the merchants in France could generally expect the same rules as merchants in Britain if they were going to trade. But what the law of torts or property was in France versus England, there might be similarities, but there was no need or reason to adopt a trans-border common general law of torts. Those were considered local matters, even if they had similar principles.
One more question before we move to Professor Harrison. Looks like we'll move to Professor Harrison then.
Thank you. It turns out that by the accident of alphabetical order, I am going last. And it turns out, now that I've heard Professor Barclay and Professor Clark and Judd Campbell a moment ago, who's also ahead of me in alphabetical order, so the whole thing fits, that I am going to try to some extent, synthesize what they've been talking about. And I'm also going to say something about the intellectual history of contemporary originalism, and work that into. The point about the intellectual history of contemporary originalism that I'm going to start with is by asking the question whether the inventor of originalism was a textualist. One answer is no, because one plausible candidate for the inventor of originalism was my constitutional law teacher, Robert Bork. Bork, you might say, began the process of founding originalism with his article in 1971, Neutral Principles and Some First Amendment Problems, in which he was explicitly non-textual about the First Amendment. Said the text of the First Amendment doesn't do us any good. It doesn't convey any useful information. Instead, we need to understand principles of free expression as part of a system of democratic government. It's a fundamentally structural argument. Keep that in mind as I say that, well, another plausible candidate for the founder of originalism was not my constitutional law teacher, but my constitutional law teacher's constitutional law teacher. That's William Winslow Krosky at the University of Chicago. I will say one of the interesting questions about contemporary originalism is how strongly was it shaped by the fact that Bork took con law from Krosky and never went to class, by his own report. But that's a great story, but I won't get into that. But I will say Krosky has a claim to have been the first originalist. In the early 1950s, I brought it with me because never travel without Krosky, he published the first 2 of 3 volumes of Politics and the Constitution in the history of the United States. And Krosky was a textualist. Krosky was a hardcore, objective, original meaning textualist. The epigraph for the first 2 volumes of Politics and the Constitution, the history of the United States, is that famous quotation from Justice Holmes about contract, in which he says, "We ask not what this man meant, but what these words would mean in an ordinary speaker of English under the circumstances." That's objective, original meaning. Textualism, that's what Krosky espoused. And as a good, objective, original meaning textualist, he hated legislative intent. He hated inquiries into what particular individuals thought. He hated the Supreme Court of the United States. He hated a lot of things. And now we're going to get to sort of the large category of unwritten law. One of the things that Krosky hated, as I say, he had a list. One of the things that Krosky hated, or one of the people that Krosky hated, was the founder of this university. He hated Thomas Jefferson. Because Krosky, although he was a hardcore, objective, original, textual meaning textualist, was also an ardent New Dealer. And because he was both of those things, he discovered the New Deal in the objective, original meaning of the Constitution, which means that he rejected the principle of enumerated federal power. That idea that Congress has only the stuff on the list, that's just bunk that Thomas Jefferson and his buddy James Madison came up with. It was a knowing lie that they promulgated in the election campaign of 1800, and they won much to the detriment of the country, said Krosky. Congress is a legislature of general, not enumerated authority. Married to that for Krosky was an idea, now we're going to start talking about unwritten law. That one of the things that was wrongly rejected when the Jeffersonians unfortunately won in the Revolution of 1800 was the idea that the Constitution brings into the United States the common law of England. Krosky said that the laws of the United States in Article 3, not Article 6, Brad was talking about Article 6, I'm talking about Article 3, as was Krosky, which are not quite the same, and Krosky was a great textualist, so he understood that. Krosky said the laws of the United States under Article 3 and hence within the jurisdiction of the federal courts include the common law of England. And by that, Krosky meant the common law of England, which was a body of unwritten law that was the law of a particular jurisdiction, as Brad was just saying. So as we synthesize this large universe of unwritten law, some part of the large universe of unwritten law can be that of a particular jurisdiction. The common law of England, as Krosky would add from his sources, he was immensely learned in 18th century legal thinking, as modified by the statutes. So that's one body of unwritten law that was quite familiar at the time of the framing. Krosky had this claim about how it worked into the Constitution. I don't think that's right, but Krosky thought so, and he certainly had evidence for that claim. The other part of unwritten law that we're interested in, sort of the rest of this large universe, is general unwritten law. General in what sense? And now I'm going to begin to sort of try to break down the category of general law as it was understood at the time of the framing. Let me stress that, as it was understood at the time of the framing. What concepts were available when the Constitution was created, whatever the terminology was. As you know, it's always a question, are we arguing over terminology or are we arguing over content? I'm going to try to look at the content that was available. One form of general law that's quite interesting, but I think not of overwhelming practical importance, consists of bodies of rules that are available to deal with a particular situation, to solve a particular problem, but that are sparse, that are general in the sense that they're generally available, and also general in the sense they don't get into a lot of specifics. Classic example of this, I don't know when this terminology was first used, but the concept was available at the time of the framing, what is now called general parliamentary law. What were the Senate and the House supposed to do when they first got together in 1789? They have power to adopt rules, but they didn't have any rules yet because they hadn't adopted the rules. The answer is they proceeded under general parliamentary law, a body of customary practices about how decision-making bodies make their decisions, and in particular about how they make their initial decisions before they've adopted their own rules. You can think of general parliamentary law as kind of like a bootloader. It is a way to get started, but it's not a full operating system. It starts up the system can then generate an operating system. It is general, and the way it gets invoked, I think now I'm trying to clarify the way people understood this at the time of the framing, is when people decide to engage in some activity, like having a deliberative body, and they generally, that word, know that there are practices about how that activity is conducted, then their decision to engage in the activity implies that they're going to do it according to the customary ways of doing it. And again, for deliberative bodies, the customary ways of doing it had general parliamentary law, and one really interesting feature of general parliamentary law, again, is this bootloader type feature it has, that is to say, it's only got the basics, it's not a worked out system. So that's one part of general unwritten law. Another part of general unwritten law, and here comes the synthesis of Professor Barclay and Professor Clark, bodies of much more determinate but nevertheless unwritten principles that go into a lot more detail than the bootloader of general parliamentary law does, that are customary, that have been developed over time, and that have the feature of generality of what Brad Clark was talking about. Well, they have a feature of generality. One feature of generality is what Brad Clark was talking about. This kind of generality is when these multi-jurisdictional bodies of law are useful to different jurisdictions that are seeking to coordinate. Brad talked about that, explained why different municipal legal systems have a reason to converge on the same rule. And that's an important form of general law, part of the content of which is it's supposed to be the same. Brad Clark talked about leading examples of this from the time of the framing. Two of them are mentioned in the Constitution. Admiralty and maritime law, admiralty and maritime jurisdiction is also in Article 3, the law of nations. I will say the law of nations at the time included, as Brad said, and I'm going to stress the one that he said maybe was less important, included both the law of state-state relations and what Story would later call private international law, the private law of nations, which are conflicts of laws principles, which are extremely important for the operation of the American federal system, because American federalism brings together states that are to some extent supposed to respect one another's sovereignty, where their sovereignty is, as Doug Laycock pointed out in that great article that summarized all of conflicts of laws in the title of the article, which is equal citizens of equal and territorial states. And that's basically what you need to know about the American federal system insofar as it bears on conflict of laws. But the important thing is the principles of private international law, unwritten, general, designed to make possible convergence, were an important part of the way the Constitution was expected to operate, because the Constitution included this system of different sovereignties that were supposed to work together, that were supposed to harmonize. So the law of nations and admiralty and maritime law mentioned in the Constitution, not mentioned in the Constitution, but very much on the minds of sophisticated lawyers at the time, was another one that Brad talked about, which is very interesting, the law merchant, general commercial law. Once again, different municipal jurisdictions had good reason to coordinate so that a person coming to the United States from Amsterdam would expect that basically the same principles of commercial law would apply. There was always some little variation, like what do you do about a bills and notes case, like Swift against Tyson. The general commercial law is an especially good example of one feature of this kind of general law. So far, I've stressed that the idea was to enable coordination, different jurisdictions, and it's like, what side of the road do you drive on? That's not so important, but it's really important that everybody follow the same rule. The content of the rules for those bodies of law, probably more important, not wholly arbitrary as between do you drive on the right or drive on the left, but convergence and coordination were very important for them. Another feature those bodies of law had and have is that they evolve and adapt over time. The decision makers, whether they be judges or legislators, continue to encounter new problems. And as they encounter new problems, they attempt to adapt the existing body of unwritten principles, without overthrowing it, to the new problems. One of the really interesting ways in which evolution works, this is the evolution of bodies of doctrine, is one that Brad Clark talked about. One of those bodies of law at the time of the framing, the law merchant, the general commercial law, evolved the way Homo habilis evolved. You know what happened to Homo habilis? It's not around anymore. Been replaced by a kind of a species of the genus Homo that calls itself wise. We won't get into whether that's a correct label or not. But Homo habilis evolved so much, it's gone. The same thing happened to the law merchant. It evolved so much, it's gone. It's been replaced by other ways of achieving uniformity. Within the United States, the Uniform Commercial Code. Internationally, various movements, UNCITRAL, for example, various ways of achieving uniformity. So those bodies of law had the two features, both of design for uniformity and the possibility of change, of evolution, of continuing adaptation, such that one of them adapted itself out of existence. It's gone. Now so that's sort of the Brad Clark part of the synthesis. Now the Stephanie Barclay part of the synthesis, which is bodies of practice that were thought of as normatively very important, that it was possible, as Professor Barclay was saying, that it was possible to point to identify with names, even though it's not possible fully to describe them, in part because they have this evolving characteristic. A great phrase about that, feature of the common law from Hart and Sachs' book, The Legal Process, is the common law cannot be imprisoned in words. It is a body of practice and the principles that underlie the practice, but cannot be fully described. It can't really be codified. It can't really be codified sometimes, but it can be named. It can be pointed to. The freedom of speech, the right of the people peaceably to assemble, the right of the people to keep and bear arms. Those bodies of what were then called and are today called rights, to some extent also have the characteristic that those other bodies of law that I was talking about, general unwritten law, like admiralty law, that there is an idea of uniformity. The idea of uniformity, though, is different, I think, for these bodies of rights that can't be described but can be pointed to, and they can't be fully described because they are whatever is the rationale that best underlies a practice. The reason for uniformity for them, I think, is different from that for admiralty, for the general commercial law, rather than a strong value simply of coordination. There is the idea that these are normative principles that people across these different jurisdictions all believe in. And the reason for them to have the same version isn't it's really important that they be the same, but rather that they all embrace them, as they often said in the 19th century. And it would be an interesting thing to learn when this was first used. The first famous use of this is, these are the rights recognized by all free governments. The first famous use of it, it comes in about 1820. Whether that phrase, Judd Campbell probably knows, whether that phrase was much in circulation at the time of the Constitution, I don't know. But these are, the so-called rights that it is possible to point to name, but not really fully to describe. They are general and unwritten, but as I say, general for a different reason. Now, I'm going to end by making a point and then raising a question, because I really don't know the answer to the question, but I think it's really important that maybe what I have said about the kind of rights that Professor Barclay was largely talking about vindicates Judge Bork. Maybe Judge Bork was right that the text of the First Amendment in this connection isn't really very useful, because all it is a pointer. It doesn't tell us very much. And maybe he was right that what it points to is a practice that is common among electoral democracies, because structurally it works it furthers the goals of electoral democracies. Maybe Bork was right in taking a fundamentally structural and only kind of a first step textual approach to the freedom of speech, the freedom of the press, because it is that kind of trans-jurisdictional body of practice adapted to, not useful in a place where they don't have elections, not useful in a place where the law is the will of the king, but adapted to a lot of different jurisdictions. The last thing I'll say by raising a question is how much the idea of those rights that can be pointed to that were known at the time of the framing, like the freedom of speech and the freedom of press and so on, how much the way those should best operate reflects the fact that they are trans-jurisdictional, that they are being worked out by a lot of different, with people thinking we're doing the same thing, we're trying to get at the same thing, again, not so much to coordinate, but for another reason, but we're all trying to get at the same thing, so that the courts of one jurisdiction would look to the decisions of the courts of other jurisdictions, the way courts of the common law look to, not in the United States, but the courts of New Zealand look to courts of Australia and Canada, because they think the common law is that kind of single body. I think that's not true anymore in the United States. I don't think that we have I think there is a general common law. We don't have it. The other Commonwealth countries have it. The Commonwealth countries, we had this. Along came General Washington upon his great white stallion, Yankee Doodle Dandy, and we had a revolution and so on. But the question I'm going to end with is whether, if that interjurisdictional evolution was part of the way those rights operated at the time of the framing, whether the structure of the American judicial system has really lost something by concentrating all decisions at a single apex court for what's now seen as federal law the Supreme Court of the United States. So that the process of evolution, which Judd Campbell was talking about, maybe the process of evolution has not been working. Maybe we're still Homo habilis. The process of evolution has not been working right because built into the idea of those rights was the notion that the process of evolving and developing them would take place transjurisdictionally, and at least for about 150 years, that's not been the way it's operated in the United States because of the role of the Supreme Court of the United States at the top of the pyramid.
Well, thank you, Professor Harrison. Thanks a lot. We have like about 5 minutes for questions.
Hey, thanks so much. That was really helpful, and I think helped to clarify certain things that I was thinking throughout. So this is going to be a little bit of a messy question, but and apologies for missing the first session, so if this was already covered, my bad. But in thinking through the first two issues, it seems like there's some sort of fundamental disagreement about like what the law is. And so I think the question I have for you is like, what do we do with two fundamentally different kinds of legal procedures that all sort of coalesce around a single issue? And the question that I have in mind here is digital free speech. Digital free speech. So in the case of the internet, we have a question that requires different jurisdictions. We also have different understandings of what the general law looks like in the European versus the First Amendment context. Inside of the European context, we have all of these claims about dignity. They've developed over time. They're very historically situated. In the United States, we have a non-Catholic understanding of what dignity looks like, and it's more Millian, it's more Lockean. I'm thinking of like the Hart's liberal boundary condition here. And so if we look at the sort of religious tradition of dignity inside of the United States, it's developed in a Protestant way between like two big conflicts. So the Jim Morone book, conflicts between individuals versus whether society is responsible for benefiting individuals. In the case of digital free speech, the democratic process here seems to not work, where you have a bunch of jurisdictions that are all around trying to do their own thing. And so it seems like this is a situation that requires something like a Supreme Court or some sort of, not a Supreme Court, but like some fixed set point to allow us to debate about issues of free speech in different jurisdictions. And so if the law is providing this sort of coordinated function, then how do we go past that when we actually have a fundamental conflict between a dignity claim and free expression? And then does this mean we need some sort of different understanding of democracy that's less deliberative and more agonistic? Or is this a question that the law can sort of help us sidestep in certain ways?
Great question. I have never thought about that before, so I'm going to give it a try. This seems to me, maybe this is just because I'm teaching conflicts this semester, but this seems like a conflicts question. That is, and it's not just a sort of an ordinary conflicts question where you've got multiple jurisdictions. It's also a conflicts where you might say, Brad Clark and Stephanie Barclay are arguing with one another. That is to say, it is a fight between the two kinds of general law that we've been talking about, between the kind of general law where coordination is the goal, and the kind of general law where the reason for commonality really isn't the interest in coordination. It is something else. I think to resolve those questions, you need to look to more fundamental structural considerations about how sovereignty is organized in the world, because one or the other is going to have to be sacrificed. Where the process, and continuing with the image of evolution, where the process of evolution has produced two species that can no longer interbreed with one another, or something like that. Sorry for the metaphor. But where jurisdictions that have a lot in common, nevertheless, have also separated from one another in very important ways. And I think that's what you're talking about, and I think that has happened. When that happens, I think the answer is the interest in interjurisdictional coordination is going to have to be sacrificed to some extent, because the fundamental structural principle is the independence of the different territorial sovereigns. And yes, there's a strong interest in coordinating whenever possible, but you can't always get what you want. Yeah.
We're about out of time, but one more question out there. Well, that's okay, because we're out of time anyway. Oh, there is. Oh, good, Stephanie.
Those are fascinating remarks, John. Just a very quick question. So, in the spirit of the idea that maybe this was meant to vindicate Judge Bork, does that suggest that maybe one of the
Krosky.
Well, or Krosky. One of the more egregious Supreme Court decisions is Bernie, because it's also preventing that sort of process of political evolution and protection of rights, and sort of the judicial supremacist approach that you seem to be criticizing.
Do I have anything to say about that? Because I have always been pro Bernie, but not because pro Bernie, but anti the judicial supremacist rhetoric of Bernie. But now that but that's because I have assumed that the Constitution has a determinate content that not only the courts can access, that anybody can access, and I have not thought about the process of evolution. And so my answer is going to be this: that I think it's probably okay, that Bernie itself is probably okay for this reason, because although to some extent it cut off an evolutionary process by saying no, Congress doesn't get to vary from the Constitution. In fact, Bernie to some extent allowed the evolutionary process to continue by letting Congress legislate with respect to what the federal government does. And so you can see Bernie as sort of a federalism decision, saying that yes, Congress can participate in the process of evolving concepts of free exercise, but it participates in a particular limited way. It participates in a particular limited way by being the legislature for the national government and using whatever leeway it has to evolve concepts of free exercise for the national government. So I just made that up. That Bernie is in fact a pro-federalism decision, but is consistent with the idea that these concepts continue to be developed, including continue to be developed by legislatures, because it keeps Congress in the federal box. How's that?
Impressive needle to thread.
Okay, do I have any last words from Professor Clark or anyone else? Okay, well, then I believe our time is up, and thank you very much. Great panel.
Thank you to our panelists. Now we have around a 30-minute break for lunch, and we'll go ahead and set that up in a couple minutes. And then the next event is our group debate at 11:45. Thank you.
Is lunch in here?
It is, yeah. We're going to switch it.
We have to break things down and move everything.